The Supreme Court just drove a stake through the heart of universal injunctions. More on that in just a second. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Now remember, I don't do politics on this channel. It's not my intent in discussing this Supreme Court case to suggest that it's a great win for the conservatives or that it's a great loss for the liberals. I'm just telling you what the Supreme Court said. It's up to you to make your own decision about whether this is a good opinion or a bad opinion. I do have to say that it was drafted only by the 6 more conservative judges on the Supreme Court, so take that for what you will. Again, don't shoot the messenger. I'm just telling you what the Supreme Court did. I'm not advocating in favor or against it either way. When the Trump administration took over, the number of injunctions that were issued against the United States government just went off the rails. Pretty much every district court in a liberal jurisdiction and some in conservative jurisdictions were issuing these injunctions, and they were essentially universal injunctions. If there was a specific, for example, executive order that they didn't want enforced, they said, you can't enforce this order anywhere. Well, there has always been a problem with that. And it's not a problem with enjoining things that are wrong, right? Because if you believe that the executive order on birthright citizenship was a bad idea and a bad thing, you're entitled to believe that, and you're entitled to go seek a remedy for it. But the problem is you can't seek a remedy for me, and you can't seek a remedy for your next door neighbor. You have to seek a remedy for yourself. But that's not what the lawyers were doing in these cases. Now, these are all very serious lawyers. They're very good at what they do, but a lot of times you get tunnel vision when you do this kind of thing. And if the trick works the first time, then you just keep duplicating that trick until it doesn't work any longer. And that's pretty much what the people who were opposing the Trump administration had done, is they just kept riding that one-trick pony until the Supreme Court had a case where it could do something about it. Now, let me explain a little bit about why this is not a good idea. And I'm going to go into the opinion here in just a minute, but the nature of an injunction is it's an equitable remedy. In other words, this is not statutory law, this is common law. Injunctions are equitable common law. And the courts of equity have a very long history. And one of the dictums in equity is that equity will not aid somebody who is in the wrong. So the way that is phrased usually is that you have to come into court with clean hands. In other words, you have to be above it all, and you can't be in the wrong at all if you're going to seek an injunction. So in one case that I was involved in, we asserted that against a drug manufacturer because they were very clearly in the wrong, but the judge in that case just ignored that dictum and issued the injunction anyway. So that kind of thing does happen, and it's necessary to be able to appeal that because an injunction is a court order telling you you can't do something. And it's worth noting that in most of these instances where it deals with illegal immigration or illegal immigrants, those immigrants do not have clean hands. They are not here lawfully. They have broken the law getting into the United States. Many of them have broken the law while they've been in the United States to do other things, other criminal acts. And so they don't have clean hands. And how you can pursue an equitable remedy for all of some group of people When some of that group of people do not have clean hands, I'm sure there are a lot of illegal aliens who are out there working hard and doing good things and taking care of their family. But the bottom line is that you can't lump them all together like that because not all of them have clean hands. So that's one problem with these universal injunctions. Well, irrespective of whether you're at the district court level or at the circuit court of appeals level, the rules of equity apply in the same way. So if you couldn't get an injunction at the lower court, then you shouldn't be able to get the injunction at the appellate court at a higher level. But that's not always the way it has worked. Now, some of the people who were opposing the Trump administration recognized early on that there could be a real problem with equity because equity traditionally provided relief between parties. Generally speaking, the equitable remedy had to be between the party wronged and the party doing the wrong. You couldn't get relief for someone else. They had to be in court, they had to be a party. Well, some of the lawyers who were litigating these cases against the Trump administration recognized this problem. So what they did was they filed putative class actions. In other words, they identified a class of, for example, all illegal aliens. And then they sued on behalf of all illegal aliens and got the court to issue an injunction again, to protect all the illegal aliens. Well, the problem with that approach has always been ascertainability. In other words, in order for a court to issue notice, and you have to issue notice if you get past the certification stage, in order to issue notice, you absolutely have to know who the members of the class are. The class has to be defined in a way that every member of the class can be identified and notified. And the problem with the ascertainability of all illegal aliens was, frankly, that you couldn't identify them all because many of them are not in government records. They were gotaways. They came here unlawfully, they haven't been detected, and they are still out there, doing something, probably working hard at a job, planting fields or harvesting crops or whatever it is that they might be doing. So that was a huge problem on that side. So the universal injunction, where the injunction just bound everybody, that was one of the solutions through this equitable procedure that everybody thought was really going to be the right way to go. Well, enter the Supreme Court. Now, I haven't had time to read through the entire opinion, but I felt like this was so important I wanted to get it out. So we're going to look at the summary that's provided by the court of what the opinion says. So they note, first of all, that there were 3 separate suits filed challenging Trump's Executive Order 14160, which was protecting the meaning and value of American citizenship. And the executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. So they challenged that, and in each case, the district court entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. The government argues that the district courts lacked equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in each case. The applications don't raise, and thus the court does not address the question of citizenship or nationality, and instead it looks at whether or not these universal injunctions are provided by the Judiciary Act of 1789. And yes, we are still litigating under the 1789 rules with respect to our federal courts. So here is the holding of the court. Universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. So what that means is that the court is staying the relief with respect to everybody who is not a plaintiff in that case. And what that means is the government can go on ahead and apply that executive order to everybody else unless and until that executive order is declared to be unconstitutional, which may very well happen in the near future. The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order, plainly warrants this court's review. On multiple occasions and across administrations, meaning not just Trump, but Biden and Obama as well, the Solicitor General has asked the court to consider the propriety of this expansive remedy. As the number of universal injunctions has increased over the years, so too has the importance of the issue. The court holds that the government is likely to succeed on the merits of its claim that the district courts lacked authority to issue universal injunctions. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. This court has held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception or at the founding. So they're taking it back. It's a constitutionalist view. It's an original intent view. It's not a living constitution view of this. Universal injunctions are not sufficiently analogous to any relief available in the Court of Equity in England at the time of the founding. And that's pretty much true. Now, later on, the defendants are going to claim, or I should say the plaintiffs are going to claim that that's not right, that there was this thing called the Bill of Peace, but the court says, no, no, no. The Bill of Peace is actually what we now have as class action lawsuits. So they take down all of these objections that are made by the plaintiffs in the case. Suits in equity were brought by and against individual parties, and the chancellor's remedies were generally party specific. The approach taken by federal courts cuts against such a sweeping remedy. So again, lots of authority, lots of history in equity in the federal courts, and there has never really been, until late 20th century, any kind of universal injunctions. The court's early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate the court's understanding of equity. Neither declaratory nor injunctive relief, the court has said, can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. That's Doran versus Salem N. Inc. In fact, universal injunctions were conspicuously non-existent for most of the nation's history. Their absence from the 18th and 19th century equity practices settles the question of judicial authority. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of the federal court's equitable authority under the Judiciary Act. And then it says respondents' counter-arguments are unavailing. That's where they deal with the Bill of Peace issue I just told you about. And they contend that the universal injunctions, or at least these universal injunctions, are simply an application of the principle that a court of equity may fashion a remedy that awards complete relief. But the court says, hey, wait a minute. Complete relief is not synonymous with universal relief. And they say here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. And extending the injunction to cover everyone similarly situated would not render her relief any more complete. So they're really holding this down to parties involved in the case, and they say respondents defend universal injunctions as a matter of policy. The government advances policy arguments running the other way. As with most questions of law, the policy pros and cons are beside the point. Under the court's well-established precedent, because universal injunctions lack a founding era forebear, federal courts lack authority to issue them. So that's the way that's going to be decided in this case. That means that effectively any court that has issued a universal injunction at this point, and there are bunches of them, the federal government is going to go in and they're going to ask that those injunctions be vacated, and they're going to get relief because again, the Supreme Court has spoken. It is a matter of settled law at this point, and for that reason, those injunctions are going to be vacated. So a lot of the stuff that was opposed under the Trump administration is now going to be allowed. This is the problem, and it's a problem for both parties with trying to solve policy issues in the court. The place you solve policy issues is in Congress. That's who drafts laws. That's who sets governmental policy. If you want to know what the public policy is on credit cards, for example, you find it in the statutes that regulate finance and commerce. That's where you find it. That's where public policy is set by the elected individuals, people who are accountable to the people every 2 years or sometimes every 6 years if you look at the Senate. That's the theory behind the republic, that the people who make the rules have to be able to go back to their constituents 2 years later and say, hey, this is what I did. Do you think I ought to keep my job? And of course, many times that's not what happens. So the opinion, I think, will be a very much talked about remedy. And if you have any questions, you can find this opinion on the Supreme Court's opinion website. It's called CASA versus Trump. And again, it is an end to universal injunctions. And many of the people on the conservative side of the aisle are championing this. And of course, there were 3 dissents by Justice Sotomayor and Justice Kagan and Justice Jackson. They dissented in this. But again, that those dissents don't hold any water. The rule is carved out in the 6, not the 3. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.